All right, ladies and gentlemen, around the Delaware Valley, welcome to the Soloff Zervanos Show here on WWDB Talk 860. We're here with our host, John Zervanos. How are you, John?
Joe, I'm well, thank you.
And so today's going to be a really interesting show. Today's show is called The Art of the Deal. Okay. What makes up personal injury and, of course, medical malpractice settlements. Okay. And John, at the firm, you guys do personal injury, but a wide array of it, obviously, including what you specialize in, medical malpractice. And of course, as basic as auto accidents, slip and falls, and those type, but also civil sexual assaults. Today, we're going to focus particularly on medical malpractice and the reason settlements. And so, the reason I want to do that is there are so many firms out there, really quality firms, that on their websites they may have medical malpractice. I've done shows with some of them, and the first thing they'll say is, don't bring up medical malpractice, because they really don't do it. They refer it to people like yourself. Okay. And so what is the in your mind, what is the main reason why not every firm, not every personal injury firm does medical malpractice and represents medical malpractice clients, even good firms, but they kind of stay out of that area?
Um, well, the obvious answer is they're very, very expensive, and you can spend a lot of money learning that you do not have a case. And just this morning, I was on the phone with an oncologist reviewing a case, and I learned that um, the nature of the facts and what had happened to this potential client of mine. It's not a case that, in his estimation, was something that was worth pursuing because it was defensible. And um, so, we got all the records, reviewed the case, had to hire an expert to confirm that it's not a case. Sometimes I can figure that out on my own. Sometimes just because the nature of the case is reasonably obvious. In this case, I had to talk to a specialist who who told me wasn't a case, and I think that's $5,000 later. I mean, I think we had a conversation months ago where I told you I had spent 6 grand learning that there was no case. So if my math is correct, there's 2 cases where we spent $11,000 combined with when learned there was no case.
Right. And so the interesting thing is obviously cost. Okay. And by the way, that's just to vet the case. Okay.
Yeah,
For
that's
our
just to vet the
listeners,
case, and then
the,
and
the,
then and then you then they're very, very difficult. I mean, and you think about it, theoretically, you can make an argument that a lot of medical malpractice cases are defensible just by arguing that medicine is an imperfect science, and that you can do everything correctly and still have a bad result. And then that's pretty accurate. I mean, and a lot of folks, they want to blame somebody, and the doctor's usually the first on their list to blame when they get a bad diagnosis or bad prognosis, and then they call a lawyer, and that you go through the process, but um, the emotions are high. It's emotionally exhausting as well, because a lot of your clients may not survive the case, especially the cancer cases. Um, if you miss a pathology where there was active disease and several years go by and now it's metastasized, odds are that your client isn't going to live to see the end of that case. And that's happened to us. And it's very, very difficult, obviously, on the client. And I don't want to, try to equate what the lawyer goes through to the client and his or her family. But you get really wrapped up into the case and you bond with these people. And you watch them suffer, and it's really it takes a lot out of you. And uh, so it's not just money, it's it's the emotional commitment that you're making to these folks. And yeah, you better be very prepared to deal with that, because
I
that
mean,
takes a lot, it takes a lot out of you.
no question. And and that's why and then let's throw in, if you do take the case, okay, and I'll kind of spitfire here, but these cases can be massively expensive and take a long time. Okay. And still, there's no guarantee at the end. Okay. And so we were just talking about the vetting process and the emotional investment. And I like what you said when you said, let's not, uh, of course, the priority is what the patient is going through and the individual, the client. And so, man, people, when you think about it, you're investing so much into it. One of the things I'd also like to throw in there is the contingency fee agreement, well, which there is no out-of-pocket cost for that client, which means the firm is investing all resources. This could take a long time if you do take the case, okay, till you get a recovery, till they get a recovery. Um, and sometimes, like you said, it outlasts the person, God forbid, but it happens. I know that. Um, but when you talk about in investing in a case, because that's basically what you're doing, because there's a lot of witnesses that you're going to have to call and experts. Um, Experts is really where I was going. How much can that cost, John? And talk about the contingency fee agreement, because that means that the client themselves, who could never afford this, okay, doesn't pay a dime. So the firm is putting every resource behind it. Talk about how much this, and I really want to talk dollars and cents, because there's a reality to it. But you're talking years. How long can some of these cases last before they go to settlement? Not to mention trial.
Well, good question. I mean, it really a lot of times depends on the court you're in. Um, Federal courts are that docket moves very quickly, and um, m most of the time you're not going to be in federal court, especially in a medical malpractice case, because you're going to either not have a federal question, which gets a little complicated, or you're not going to have diversity of citizenship, which means when you have two parties from different states, oftentimes you can, well, not oftentimes, you can by rule file it in federal court. In some cases, if the defendant or the plaintiff is out of state, but you want to sue in state court, the defendant can oftentimes remove it to federal court, because federal court, um, there seems to be a school of thought that federal court is going to be a more conservative jurisdiction, which be less favorable to a plaintiff. Not so much because the judges may be more conservative, which in my experience, I have not found that to be the case. But the juries are going to be more conservative, because if you compare a federal jury to a Philadelphia jury, you're going to get a pool of jurors from what's called the Eastern District of Pennsylvania, which means you're going to get jurors from not only Philadelphia County, but you would get jurors from the collar counties, Chester, Montgomery, Bucks, Delaware, and or you can go one layer out to Northampton, Lehigh, Berks, and Lancaster, and you're getting even more conservative. So it's really all about the jurors, and that really drives, defendants to pursue settlement, because if they believe that they're exposed to a potential verdict, that's going to encourage them to go to the settlement table. You still have to be able to prove your case, and you got to show them and demonstrate to the defendant that you have a good case and you have strong witnesses to stand behind the case. But, I'd be not be I'd be doing a disservice to the listeners if I suggested that venue doesn't play a role in how these cases are evaluated.
But these can take several years, correct? In other words, um,
Well, in state court, the beauty is in Philadelphia, they do a great job at moving the cases. There are courts outside of the county of Philadelphia where I'm not going to name them, but it's considerably more challenging to get to a courthouse and get a trial date, and that's enormously frustrating for the plaintiff because if you're a defendant and you know you're not going to be held, your feet aren't going to be held to the fire for several years, even under the best case scenario, you're not going to be all that interested in trying to resolve a matter. And that's very frustrating on our clients because they sit and wait and wait and wait, and they just get more and more bitter, and they feel like the system has failed them. And when they get more bitter, it becomes more difficult to settle a case because now they're so angry that they want their day.
right. Well, and John, let's talk also about the cost often. Now, when you are putting deciding a case that if you're going to take a case, okay, one of the things we've always talked about is the fact that when you're obviously when you say defendant, we're talking about, just so our listeners understand, the insurance company, okay,
Well, that's technically the insurance company is not the defendant. The
right.
insurance company is the entity that's paying the claim. But when you see the verdict sheet, it's against the doctor or the hospital system. It's
Right.
there's no one knows anything about the insurance companies.
Okay. So having said that, um, when you talk about the investment for the experts, when you take a medical malpractice case, when I say this, well, obviously, somebody, a plaintiff, a person who has potentially has a medical malpractice lawsuit, um, you want a firm that has the resources to be able to go the distance with, obviously, the defense, the big insurance companies, and at the end of the day, um, you're also looking at quite a cost. That's why a lot of regular firms, personal injury firms, don't take medical malpractice case. The length and the cost. How much do you? So you got to make sure the firm and the attorney you retain um, has the resources to be able to go the distance. How much have you in the past, John? And let's highball it. Let's not let's take two figures. Number one, how much has the firm had to invest? How high is it going to invest in a medical malpractice case at the highest? And then what is the average that you have to make sure that you guys are ready to spend in representation of your client?
The reason why a malpractice case is so expensive, um, oftentimes you need to get a standard of care expert, which requires you, if you're dealing with someone who misread a diagnostic image, an MRI, PET scan, X-ray, you're going to need a radiologist to speak to that misread, and that's your standard of care expert. In some cases, the judge will allow that radiologist, if it's a misread case, to comment on the delay and what that might do for the patient's prognosis. But oftentimes you have the radiologist who will say the radiologist defendant misread the scan. It went from a stage one to, let's say, a stage three or a stage four tumor. But that radiologist might not be allowed to testify as to the staging. You're going to then have to bring an oncologist in to speak to the staging. Or you might have to, if it requires another medical discipline, you might have to bring a neurosurgeon in to talk about, like I have a case involving a spine issue. So not only do I need an oncologist, but I need a neurosurgeon to speak to how the spine deteriorated because of this delay. And then you need the radiologist to speak to or comment on the misread that started the catastrophe. And in some cases, you might need another expert. So that's four or five experts right there. So not only do you have to pay them to review the case and then give you an opinion, But then if it has to go to trial, you got to pay them to get on a plane, travel to the courthouse, sit through a day, and you have to time it just so perfectly so that it's very, very efficient. They're getting off the plane. You have somebody there to get them, drive them to the courthouse. Sometimes they got to stay overnight the night before, and then they leave the next day. But everything's got to work according to plan, and nothing in trial works according to plan because there's always an upset somewhere. So your trial can cost $100,000 without blinking when you have all those experts. And what folks don't really understand is when you go to trial, you're not standing there with butcher boards and paper anymore. You bring a professional in there where all the records are downloaded into a laptop. You got the big screen, they got the projector, and you got everything up so that the jury can see everything, on a screen. There's a famous lawyer in Philadelphia who coined the phrase trial is theater. When when a jury comes to court, they're looking for a production because they want to see that you've got it all together and you're putting it out on a big screen and you're being able to demonstrate to them where the mistakes were made and how it's impacted on your client. And you can't stand there with a 3x5 card or a little picture. That's how you're going to win. That's
Yeah,
not
you're
how
not
you're going
you're
to win a
not going to
case
have a chalk.
exclusively.
You're not having a chalk.
Yeah, all that costs money. And if the case is going for 2 weeks, it's 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 hundreds of thousands of dollars just for one case sometimes. Therefore, your damages have to justify the expense because you're dealing with, a person who's not severely injured. The cost will cost more than the value of the case. So you got to go through all this analysis to decide whether or not, it's not only worth your time as an attorney, but it's also worth, the client then is expecting a result. And it's a hard pill to swallow when you tell a client who's been a victim of malpractice or, victim of anything for that matter, that their damages don't support the case. And then as a lawyer, you don't really sound all that sympathetic, frankly.
Well, it's interesting because it's a science that, although inexact, you need to really. To me, that really is just intriguing, because you have to make a decision on behalf of that client because they're going to have to go maybe through several years, and you want it to be worth their while as well. When we talk about the contingency fee agreement, first of all, quick yes or no, the credibility of your witnesses matters because you can't just get if the insurance company's bringing top experts in, you just can't bring in some individual who's in his second year, of the that specialty. Does it matter the credibility of the witnesses you bring in, and therefore
It's
somewhat?
it's it's absolutely huge. And the most credible witnesses are going to be extremely busy physicians who aren't going to stop what they're doing in their day job to get involved in a trial or a legal malpractice, medical legal situation. Um, so getting a competent, well-credentialed expert is very challenging for the plaintiff's lawyer. And it means everything. You need somebody up there with the gravitas to explain why this group of physicians are responsible for your client's problems. And you can't bring somebody in off the street, like you said, who's inexperienced, who might be a community physician who doesn't have the credentials to support. I mean, he might be able to support his opinion, but he doesn't have that CV that carries the day. And, guys like me, we like chairman of departments We like folks from Harvard and Yale because almost everybody knows that if you're going to be on staff at one of these prestigious places, you probably know what you're doing, and what's coming out of your mouth is gospel.
So when you talk about these experts, obviously they're not waiting to the end of the case to see if you won to get paid. Okay, they're not on
They
contingency.
get paid. They're
Okay,
getting paid no matter what happens.
right. So the point
So
is,
if the lawyer loses, not only do we lose all the time we invested in the case over a 3 or 4 year period of time, but if we put $100 to $200,000 in the case, you lose all that too.
and that's what I mean.
So
In other words, you're paying for them out of your own pocket in representation of your own client. Okay, and there's a lot of risk there. And at the end of the day, when we're talking about the contingency fee agreement, okay, there's no out-of-pocket cost for the client, okay, but the magnitude of the case increases the, like when you're talking about these big cases, increases the risk for the firm, okay, and I understand that it's important. Obviously, you get emotionally invested in this as well, but in order to be able to represent clients, you have to be willing to put that money out of your pocket and not be worried about your rent. Now, here's a question. At the end of the day, okay, um, you have what I want to break down the contingency fee agreement. So, what is the formula typically when it comes to your agreement with the client, and these expenses come off the top, right, of a settlement? But if you don't win, the client pays nothing. Okay, so the risk is completely on the firm. Okay, so let's talk about what's important in regards to the client understanding that. Okay, um, uh, uh, what is the formula in regards to the percentage range that the firm will be on in regards to the contingency fee agreement, and how does it work when do these expenses get paid or reimbursed?
well, the expenses don't get reimbursed until
You
you
get a
get a
check,
check,
right?
whether you settle the case or you get a verdict. Um, then the law firm is paid, and then the law firm gets reimbursed for all their costs. And once that's done, the client gets the balance of the net recovery. And certainly, we explain to the clients, here's the fee, and these are our costs. And if we have to try the case, expect our costs to go up X dollars. And that's important for them to understand, because if you're debating whether or not to settle a case, provided you have that opportunity, that's another thing. But provided you have the opportunity to settle a case before trial, you as a client need to understand what you're risking. One, you're risking losing the case. And two, you're risking making a recovery, but then spending all this extra money to try the case to get a verdict. And then is your net recovery going to be the same before trial or after trial because of the expenses associated with the trial? And then you have the unknown, the great unknown of whether or not you're going to win the case. I've had clients turn down offers, and then you go to court, and your first day in the courtroom is you have to pick a jury. And that can be unnerving, because you're sitting there watching the lawyers go through the process of picking a jury, and that's a process in and of itself. And you're seeing these people holding
Your
your
life
your
in their
your your,
hands.
your well, it's not so much your life, because if you lose, you're not going to jail, but
No.
but there's a lot riding there.
So how
And
about
you know
the quality of your life potentially? If somebody, if we're going to get into what makes up that with an economist and all that, but a large, the quality of your life and your dignity could be on the line, because especially if you can't work.
Sure. And the whole idea of bringing a lawsuit is to regain and secure the financial, you're trying to get financial security so you can either have money for your medical expenses or money because you can't make the same living as you used to or now are disabled. And we haven't even gotten into, the non-economic damages that include just how your life has been affected so significantly that you've lost your dignity in some cases. You've generally lost what makes you happy. I mean, I always tell juries when I'm closing to them and I'm trying to help them understand what we're looking for. I tell a jury sometimes, not sometimes, I try to say this to every juror. We're put on this earth and the whole when we look at our life, we're not thinking about what we're doing Monday through Friday. I mean, granted, if you're fortunate enough to really love what you do for a living, um, we're gonna appreciate the fact that we love our vocations and we love what we're doing. And but when you really stop and think about it, what do you love? You love your family, you love your free time, you love your vacations, you love what you're doing on when you're recreating and enjoying your life, your holidays and so forth. And when you can't have that experience like you always have had it in your life, those are the real losses. They really are the real losses in a case. And you know, when someone loses someone to a wrongful death, and you have the widow or the widower that was used to having that person every day in their life for 40 years or 50 years, or God bless them, 60 years, and suddenly they're not there anymore. Think about the extraordinary loss that is for that human being. You know, loneliness and fear are probably the most two of the most significant emotions that a person can have. And we all fight through life to prevent ourselves from feeling fear and anxiety and being lonely because you've just lost the folks that made you whole. And that person's now gone. And now you have to fight the fight by yourself. And in an older person, hell, man, it's in a younger person. It's just an enormous loss. And you wake up every day for the rest of your life missing that human being. And my goal when I'm in a courtroom is trying to really help a jury understand where the loss is. It's easy to pull out a calculator and crunch the numbers, medical bills, future medical expenses, wage loss, future medical expenses, and you can type it all out and you get your calculator out and there's your number. You know what? That's a significant damage, but now we're going to throw it to the side and let's talk about the real loss in this case.
Yeah.
And to me, that speaks to me as an attorney, and that's why I became a lawyer. Those losses are
Well,
enormous.
it's amazing because you've touched, uh, and they're the non-monetary. While we're on the topic, okay? Because, um, you know, the legal field now more than ever, right? With advertising and client advertising, they show a lot of people and they all got their business models. And I'm not, I'm not criticizing anybody, but you get a lot of these law firms that, or individuals that are just holding money bags up and on. It creates, in my opinion, um, a misconception of what you're doing. And what you said there, John, really speaks volumes because you get a lot of, and advertising that just focuses on get your quick cash, like it's ridiculous because no matter, what you just talked about, what comprises, let's officially talk about the elements that factor in on a settlement, or, that, like, you said, obviously the monetary losses, you can't work anymore. You're going to have, you're going to need medical care and all these things. And then the non-monetary loss of life's pleasures and a lot of those things, they make up that number. And as a lawyer, the responsibility that you have, in my mind, is just unimaginable, because it's your job, obviously, and I know you get an economist in some certain situations to kind of put those numbers together to make sure this person has a dignity for the rest of their life, and that they can live, especially if they can't work, and they're raising a family and all those things. That money bag that's up on that billboard sometimes, or on that bus, doesn't tell people that really, it's a misconception, in my opinion, of what it really is about. It's not, I feel like, okay, I'm going to get that and go on vacation and go party. That's ridiculous. Let's talk about the factors that go into a
You
settlement.
know, you know, that money bag that you see on the billboards, or the money bag that you're talking about, it can change someone's life to the extent that you're giving them money to help provide for themselves and their family. There's no question about that. But at the end of the day, what brought you to this point of fear, anxiety, distress, loneliness? When you get your check, and this is the non-economic stuff, when you get your check, you're still sleeping in that bed by yourself, or you're still in that wheelchair, or you still have that chronic pain, or you still are in fear of having that cancer come back because somebody they delayed in their diagnosis, so your prognosis is now changed. You're still waking up with all those issues that you're trying to manage. The only difference is now you have a check. And I tell people all the time when they have chronic pain, I just want to make sure you understand that when you get your check, your life and the problems that you're experiencing, the non-economic problems, they don't go away. You're still going to deal with those problems and have to learn how to manage those problems, even though your case is now over. And there's no magic pill that we are serving as lawyers to eliminate that pain. The civil justice system allows you the opportunity to be compensated for the anxiety and the loneliness and the fear and the pain, but it doesn't go away. And a lot of clients hold on to their cases thinking, well, when my case is over, well, when my case is over. Your case will be over someday, but your life, in terms of non-economic damages, your bills might be paid now. You're getting a little help now because you can't work. That part of your life gets easier. But those non-economic issues stay with you. And that is really a hard pill for a lot of clients to swallow, because they realize, well, justice for me doesn't mean my pain's going away. It means I'm getting paid to endure it. That's what
It's
it
just,
means.
it's incredible, John. And when I think about, that type of situation, um, talk about that post settlement type of, well, okay. So let's talk about the art of the negotiation. Okay. Um, let's talk about when, when typically settlements come up, the decision to go to trial or not go to trial. Um, you have a case, and in your case with personal injury, they typically last longer than, um, like a car accident or something like that. Which, by the way, they don't just send you your check like you would think because you paid for insurance, but auto insurance. But aside from that, let's talk about the actual process, John. When let's just say, um, you're at the I'm just picking random numbers, but you're at the 2 year mark. When do you start typically seeing, and regardless of how long it's been, when do you typically start seeing offers from the defense to settle?
Probably when you've created enough risk. You've created enough risk either through deposition testimony or evidence that you've been able to develop. And when that defendant believes that they have a problem, they're going to start talking to you. Um, an example I can give you is if you have, we haven't talked about defective products. A lot of these companies don't want to believe that their products aren't safe. And if you demonstrate to them that there's this safer alternative, they'd either cost just as much or not that much more, and then your product would have been safer. Companies hate that because a jury's going to say, well, you're just trying to save money. That's why you put out a product that wasn't as safe as it should have been. That speaks to the biggest companies in this that are in this country, and in foreign corporations are even more exposed because the nature of our politics. You know, jurors have I believe, have a predisposition to find foreign companies more responsible than domestic companies. With a doctor, you have to be able to demonstrate to this doctor, because no doctors want to believe that they breached the standard of care. And if they do believe it, they're telling their carriers, pay this claim. Just let it go away. But they have to be convinced that they really did breach the standard of care. And then they have to be convinced that the breach caused the damages that were being alleged. And when you convince them or make them feel like there's a significant likelihood that they could lose, that's when they want to talk to you about settlement. And that can take some time. I mean, if you rear end somebody, everybody knows you're not supposed to rear end somebody. So this car accident case is a whole different analysis, you know?
Well, um, so I've often heard that settlements sometimes happen when you're on the courthouse steps. Um, is is there any truth
Sure,
in that?
that's absolutely true. I mean, because now it's almost having a gun to your head for both sides too. I mean, you're about to spend all this money. There's huge risk for everyone, but particularly for the plaintiff, because if you're a defendant and you lose, you go back to your practice or you go back to making your widgets again. Um, but if you're the plaintiff and you lose, you're going back home with an empty bag, and you just felt like you were trying to hold somebody accountable and you lost. It's almost like you're wearing the scarlet letter that you felt condemned to this life because you believe someone made a mistake, and you didn't prove your case, at least to a jury, and you lost, and you went through all of that almost for nothing because there's no accountability. In your mind, there's no justice. And for most people, accountability is huge because it justifies the effort and justifies why they're doing what they're doing. Um, and a lot of these folks are really angry, and that helps with the anger. Um,
How
I
often?
gotta tell you,
Go ahead.
well, go
No, go
ahead.
ahead, Chuck. Go ahead.
I will tell you that anger is an enormous motivator for a lot of my clients in seeking justice. Accountability is almost like the panacea for their ailment. They were able to hold these folks accountable, and therefore they feel justified and feel like the system served them well. Um, yeah, they want money, but that accountability is huge.
Well, I was going to ask you about that, and I've heard this so many times, a lot from yourself. The of obviously the check when there's a settlement uh, or a verdict, but a settlement we're talking about is obviously important because they want to live the rest of their lives. They want to be able to live the rest of their lives and all that. But you mentioned something really interesting, and that is, and I'll say change happens in the courtroom, um, but how often, and this is typically a question I ask is how often does the plaintiff, the person who's been wronged, um, is there an additional motive in regards to, of course, they want to be able to live and they need to replace their income and all those things. But the message that they're sending, and justice, um, how and not wanting what happened to them to happen to somebody else. How often does that coincide with, okay, seeking justice for themselves and their family who can no longer obviously provide or live in the in the circumstances that they once did. Okay, that is obvious that they need that, but um, how often is the motive? Yes, I want justice, but I also don't want this to happen to somebody else.
All the time. It's usually in that first conversation where someone will tell me, I don't want this to happen to somebody else. I'm doing this so it doesn't happen to somebody else. And I always tell folks that um, I don't know if your lawsuit will ever keep something this like this from happening to someone else. But what I can be sure of is if the exact scenario occurs in the future, that doctor's going to be that much more careful because they're going to recall this lawsuit and they're going to recall what they had to go through because they didn't take that step or they ignored the step they were supposed to take. They might be that much more careful. And in that regard, you may prevent that from happening to someone else. Now, I know in the product's liability standpoint, if you've got cases that are where corporations are being held accountable for some defect in a design of a product, you can be sure that that company is going to change the design of their product so that other people aren't getting hurt because they can't afford to stay in business. So your lawsuit and other lawsuits will make a change. And that is certainly the beauty of the civil justice system. You can you can create change in doing what you're doing. And that's what the system is designed to do. I mean, you get this micro benefit in terms of helping your client, but you get the macro benefit in potentially helping society because now you got safer products. I mean, the airbag fiasco that we had years ago, all those airbags and the way they were making them and installing them in cars were changed because the propellant they were using was so violently it was so violent when it impacted someone's face it was killing them and blinding them. The companies went back and they changed the way that was done, and you don't hear about airbags blowing out people's eyes or killing them
Well,
anymore.
I always give the example, and I've done it on our show 100 times of that my next door neighbor's truck backing up and hearing the beep 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 beep. That you can contribute that to somebody like John
Absolutely.
Zervanos to make sure because
Somebody filed a lawsuit and said, if you can't see behind you, shouldn't you make it so that you can create a warning system so that someone who you can't see might know that you're backing up?
That obvious. I mean, that is 100% true. But let's also look at the fact that it was likely because somebody was hurt badly, and and and
Correct.
and it was a lawyer like yourself that held that person that or that company accountable. And it was through somebody else's devastation. That is what is so important. Okay, when you talk about justice, and what plaintiffs' attorneys do. I mean, to me, it's a heroic situation. And I mean that sincerely because if I was going to law school and I didn't know anything about the law and I had heard about the contingency fee agreement, and I'd be like, just at first sight, you mean to tell me I'm going to work for 3 to 4 years, put up my own money, okay? If I don't win, I don't get the money back, and I don't get paid, okay?
You can go bankrupt pretty quick. So you better be pretty sure that you're confident in winning that case. I tell clients all the time, if I take your case, it's because I think I can win it.
Obviously,
But it comes with no guarantees.
but John, let me ask you a couple. I know we're coming down to the nitty gritty, but when we talk about the art of the deal, I'm going to ask you about client misconceptions, last. But what when you get an offer from an insurance company or whoever the defense is, and I'm going to go through a couple scenarios. I'm going to answer the first one. I'm not even a lawyer, but if it's an insulting offer, I'm sure it's easy to sit down and go, this is ridiculous. And I'm sure you get them, and your client couldn't live with that. So it's easy. I know it's always up to your client. That's I'm sure easy. But when it's a reasonable offer, but still maybe not enough. Like, I'll throw something out there. Say you've got an economist and you put everything together, and this person's going to need they're 50 years old. They may live another 30 years, or they're 35 or whatever. You've got the estimates of what it's going to take for them to live, but you get $1.5 million offer, but it ain't enough. And it's only going to take the person so far. It's not insulting, but it's certainly hard to turn down. Talk about that and how you talk to your client about, okay, since they're ultimately making the final decision, talk about the responsibility of having that conversation with your client, because that's not quite as easy. It's not an insulting offer, but it's something that may cause them challenges for the rest of their life if they accept it.
It's what I call those sweat zone offers. The offers doesn't make you entirely satisfied, but it's in that sweat zone where you're sweating because you're like, man, I should take this. Maybe if I don't take it, and there's this whole big debate, and that's where you think your lawyer's going to give you the right answer, and the lawyer's right in there with you saying, yeah, well, this is what I call an offer within the sweat zone. What are we going to do? It's probably enough money where you probably should really, really consider it because the chance is you might lose. It's easy when they give you an offer that's too low because then there's no debate. And then obviously if you get an offer that's above your sweat zone, that's winning with house money. And that every once in a while happens as well. But your responsibility as a lawyer, I think, is to make sure that the client doesn't have undue expectations. And you can try to control that from day one. Because the more emotionally invested a client gets into her case, the more difficult it is for you as a lawyer to be able to settle your case. And you just have to constantly, constantly educate the client about what the real value of the case is. And, where are you litigating this case? Where are you trying this case? Are you trying it in a case in a place where people are very, very conservative and, millions of dollars is so far out there for them to even remotely contemplate? there's no chance you're ever going to get that kind of award. You have to make sure that the client is educated. An educated consumer is your best friend. An educated client's your best friend. They used to call us counselors for a reason. We would counsel people, and the goal is for you to counsel them, and they have enough trust in what you're saying that they're going to follow your advice, and you're going to be able to get a good result for them. They might not be entirely satisfied with the result, but they understand why they made the decision.
So you would
And that's
educate them
crucially
on,
important.
and you would break it down. I'm assuming, and educate them on every factor, and then let them. Obviously, they have to make the decision.
Every factor, every single factor, you got to go through it in fine detail. This issue, here's our problems with this issue. Then we have this issue, and here's your problem with this issue. And then you got to be willing to be able to testify about it. Some people don't want to air their laundry in a courtroom. I mean, it's embarrassing, and or it's just very difficult to talk about your own loss. Like, it's not a walk in the park, and the stress is so it's enormous, and you don't really appreciate it unless you're in there. That's why I told you, the client will be like, "Oh, I'm all about trying this case," and then they get in a courtroom to pick their jury. Just picking their jury is so intimidating. They realize, I got to get out of here.
Right. That makes sense, and certainly, it man, it's a responsibility that you got. The more when you listen to the factors that are involved, that it's clearly why most attorneys, and it's so rare for like attorneys to have to really be medical malpractice attorneys. There's so few that are at this level. So John, before we roll out, we only have a couple minutes, but misconceptions that clients have sometimes when it comes to any part of the medical malpractice situation that sometimes come up after a buyer's remorse, if you will, if because of misconceptions, even after you've explained everything possible. Give me some of
One
them.
of one of the mis one of the misconceptions that's a huge misconception is, as attorneys, we kind of fight the advertising that we see. We see it as well. And you hear the advertisement, so we got, somebody, multiple millions of dollars for an injury that you're like, what? Like, how did that happen? There's
Yeah.
always there's always a story behind the story. And, like kind of like the McDonald's, the coffee case that we all, was an albatross around all our necks for so long because no one really understood the true story behind the McDonald's coffee case. So advertising in the media creates expectations and misinformation that we now have to undo for the clients. You're not getting $1 million for a broken arm. Sorry, not happening. You know?
Yeah. I mean, and that
And some people are like, well, what do you mean? I'm going to go to that lawyer who advertised that I can get millions of dollars, you know? Uh, okay, but it's not reality.
and I imagine in a lot of ways that as an attorney with integrity, the truth is the one, it's a factor
Yeah,
that's on your
you want me to put rose-colored glasses on for you, or you want the truth? And if you place the reality out front from day one, you're going to have an easier time walking that client through the journey of his or her litigation.
Yeah, and we've talked about it many times, setting them up for success and not failure, especially in a medical malpractice situation, where the ebbs and flows happen, and they happen sometimes over a large amount of time. John, obviously, fantastic show. We've come to the end of this journey, and I really appreciate your insight, but also your passion and your emotion. To me, a plaintiff can't ask for any more. Somebody going through such difficult situations, many where the individual that comes in for the case may not be there at the end. And, so I really appreciate that. Obviously, John, if somebody wants to get in touch, what's the contact information at the firm?
So, soloffinzervanos.com. You can get everything you need to know about our law firm. And if not, you can call us at 215-732-2260.
Soloffinzervanos.com. And of course, want to thank everybody for tuning into the Soloff Zervanos Show here on WWDB Talk 860. We want to thank our host, John Zervanos, and our Art of the Deal, all the elements that go into a settlement when it comes to obviously personal injury, but medical malpractice cases. What an education. John, thanks so much for being with us and for doing the show. And of course, I want to thank our listeners for tuning in. On behalf of John Zervanos, I'm Joe Doherty. Thanks for listening, everybody.